hot mic now. We'll go ahead and get started here. It's about 10 after. Really happy to reintroduce Joe Ellen Whitney with the Davis Brown Law Firm, and I think the term embarrassment of riches comes to mind. Joe has a very in-depth knowledge of a lot of different areas in law, including labor law, and what she's going to talk about today is health law, and in particular things that come up on an almost daily basis in EDs and hospitals and doctors' offices every day across the nation concerning the legalities of certain things that we do with and for patients. Please fill out your evaluation form after the completion of this activity, and if you have any ideas for future programming for our continuing medical education series, we'd love to hear about it. Please join me in welcoming Joe Ellen Whitney.
Hey guys. You really do give new meaning to the term backbenchers. You know, I'm looking straight up, so like if I get a crick in my neck, it is all your fault, all right? All right, so I am here today to talk about mental health issues, those kinds of things, as we deal primarily with the emergency department, but I also understand that there's a number of other questions that might crop up. Doesn't the top, where's my tech person? Doesn't the top supposed to advance it? It is not. There we go, that's me. I'm a senior shareholder at the Davis Brown Law Firm. I do labor and employment, healthcare law, privacy and security, litigation. Pretty much I just do everything that's geeky, okay? So if it involves geekdom where you need to know what the term in Klingon is for something, that would be me. If it involves a dead body, a lost body, a body part we can't find, that would also be me. So geeky and crazy would be the work that I do, which makes it perfect for me to talk to you all about mental health issues, right? Because I do a lot of that. That is the disclaimer. I don't even know where I am here. That is, okay, no, the disclaimer's okay. So, I don't know, they're going all over the place. So, a minute ago we had a disclaimer. The disclaimer basically says, there we go, the disclaimer basically says that everything we do is complicated. This is the real disclaimer. You think I'm talking about you, but I am not. Okay? Because every hospital, every doctor, every facility, every clinic has the exact same issues. Now, maybe yours is dressed in purple instead of blue, but you got the same issues, okay? And when I start talking about some of these things, I am not ever going to use an example from any of you. I will not use an example relating to your facility. Now, Donna, you've been at more than one place, so I might use one you recognize, okay? But the thing is that we all face the same problems. We all have the same complexities. We all, okay, face the kind of things that we do. The other thing is that when we talk about this stuff, there is the law, which is really a complex entity when we are talking about mental health, when we are talking about release of information, when we are talking about any of those kinds of things. And then there is the way the world really works. And the way the world really works doesn't always match up with the law. And so my job is to try to make that gap a little smaller, but also to make it make more sense, okay? So in doing that, I want to just, before I go to my next slide, I want to talk just a little bit about what I think are the golden rules, okay? So the golden rules when we're talking about this stuff. Number one is it is always about the best interest of the patient. At no point in time is it ever about anything other than the best interest of the patient, okay? Now, there is one small exception to that, which is when your patient is intending to kill someone else, okay, which would be the Tarasov Standard, and we're going to talk a little bit about that. But in general, it is always about the best interest of the patient. Number two, consent matters. Your ability to consent, whether that is to treatment, to the release of your information, to being held in the hospital, is important, right? It is a legally defined right. It is a constitutionally defined right. Consent matters. You have the right to withhold consent even when we know better, right? And lots of times we know better. But you still, as a patient, unless there are certain things met, have the right to withhold consent. So consent really matters. It is a limited time when we would abrogate somebody's right to consent. Here's my third golden rule. Law enforcement, lawyers, and sometimes family members are bullies. We are. We think we know. And here is the thing. Being certain about something, absolutely certain, does not mean you are right. okay? And you will get a lot of certainty from lawyers. You will get a lot of certainty from law enforcement, and usually, unlike lawyers, they have guns. You will get a lot of certainty from law enforcement. You get a lot of certainty for family members who think they know the answer and you don't, or the patient doesn't have self-determination. We're all bullies, okay? But that doesn't mean we're right. And so the point there is if there's a question, check, right? So yesterday, I spent part of my day on a conference call with a couple of hospitals and a bunch of law enforcement agencies. And they kept trying to bully me, not the hospitals. They kept trying to bully me, and I kept saying, I understand your point, but we're going to have to disagree, right? Because they have a very narrow viewpoint. Law enforcement has an extremely narrow purview, right? It mostly involves when people get hurt or theft, that kind of stuff. You all have to think about the world, right? You have to think about these big universal principles. You have to think about HIPAA. You have to think about 42 CFR. There's a ton of stuff you have to think about, not that very narrow grouping of things that law enforcement thinks about. So that puts a slightly different burden on us, okay? And then the final piece is what I have always called the Tarasov Standard, because it comes from the Tarasov case, which is basically something part of something bigger. Nobody dies because of HIPAA, okay? Nobody dies because of confidentiality. When we talk about HIPAA just generally, when y'all go all the way back to Hurricane Katrina, there were people that claim that their hospital, their provider would not release their medical information or the continuity of care information because HIPAA prevented them, and those people suffered injury. Okay, so there's a lot of claims of that. So the Office of Civil Rights, who enforces HIPAA, released the Katrina memo that says, basically, you can read the whole thing, it's like 8 pages long, nobody dies because of HIPAA, right? We have a potentially reported Ebola case in Pennsylvania right now, right? That was on this morning's news. We have this potential Ebola case in Pennsylvania. You don't keep that secret, right? That's a public health exception. Well, the Tarasov Standard, and I'm sure y'all learned this in med school, is also now codified in Iowa statute. That's Iowa Code 228-7A, and it basically says if your patient is an imminent risk to someone else or him or herself and has the capacity to fulfill whatever dangerous thing they're going to do, like kill somebody, then you have the right to tell law enforcement. Okay, so it's an imminent risk assessment. That also becomes part of how we look at involuntary commitment about those kinds of things, but it is an imminent risk assessment. It doesn't mean someone, right, says, eventually I'm going to kill them Patriots, right, because didn't they just win the Super Bowl, right, the Tom Brady thing? I saw a lot of Twitter stuff about how Tom Brady was going to get killed. You know, I'm going to kill them Patriots, right? But they have never been out of the state of Iowa. They have no income to go out of the state of Iowa, and they have no plan. That's not imminent risk. I'm killing my ex-wife and her new boyfriend, and I got a gun in the car. That's an imminent risk, okay? And so there is an assessment for that, and there's some factors they set out in 228. So those are kind of the golden rules, right? The biggest one there, best interest of the patient, nobody dies, right? As long as we keep that in mind, we're usually doing pretty good. Okay, what we're talking about for state law, right? There's a lot of complexity in state law. There are a lot of different pieces to state law. Primarily, it is Iowa Code Chapter 228. 228 is when you are voluntarily seeking mental health treatment. So 228 is I am seeking mental health treatment. It's also voluntary hospitalization, those kinds of things. I'm seeking mental health treatment. 229 is when you are involuntarily being treated for the most part. Now, this is not precise, but more or less 229 governs commitments, they govern medical holds, those kinds of things. 125 involves substance abuse, but a lot of times 125 just refers back to the others. And then you have the prescription monitoring program. So you have the monitoring programs, and there's some different rules that attach to that. For federal law, we're talking about HIPAA. Okay, and the first thing that we're going to talk about here is we're going to talk about the primary law enforcement exception to HIPAA, but we're talking about HIPAA. If you have a Part 2 program, so you are a federally certified drug or substance abuse treatment center and you have a Part 2 program, that is a whole different set of rules, okay? Does anybody in here work in a Part 2 program? No? Okay, that is very much a different set of rules. And the other thing I didn't say earlier is that if you have a question or you want to tell me a story or you want to just disagree with me, I'm fine. But I would if you have a question, you have something you want to clarify, you have a circumstance, let me know. Because I would much rather tell you or talk to you about the things you're genuinely concerned about or where you have an issue rather than just keep talking. Now, I can just keep talking. This is a short speech. It's like 35 minutes long. I can just keep talking. But I want to make sure that if you have something, you know that you can just raise your hand. And if I don't see you because you're all the way over there, whoop, okay, and I'll know. All right, so the other thing we have is FERPA, which is the Family Educational Rights and Privacy Act. So if you were running a clinic in conjunction with the university and you were subcontracting with the university, not only do we have HIPAA, but we also have FERPA, okay? And they interact, right? They bisect, they have very similar rules, but they are not identical. So whenever it is a university-sponsored thing, if you're a subcontractor or a contractor of the university, we're going to have one more set of regulations that we have to think about. In Iowa, you also have, under 228 and 229, specialty regulations for mental health, okay, and specialty regulations for substance abuse. So, okay, let's talk about the police. HIPAA is a rule that encompasses everything. Okay, so it is all-encompassing. Everything is confidential unless you can prove it fits in an exception, right? So you start with the base premise that everything is confidential, including your ex-boyfriend's new girlfriend's medical records, okay, which is the one I get a lot. Yeah, I get a lot of people looking up their ex-boyfriend's new girlfriend or their ex-girlfriend's new girlfriends or their son or daughter's new date. They want to know if they ever had an STI or any of the rest of it, and they tend to look that stuff up, and then they share it. Okay, so we get a lot of that. You all know better. Not everyone knows better than doing that. So we get a lot of that. The second piece about HIPAA is that patients have to know how their information will be used, right? And if you're doing one of those things where a patient wouldn't know you're going to use their information that way, like, I don't know, giving it to the boyfriend or something, that's also going to be a violation of HIPAA. So those are the broad principles, right? This idea that everything is confidential and patients need to know how we use their data. The main exceptions to HIPAA are treatment, payment, and operations. So you can share. I have no idea what specialties the two of you have right there, but you could share information on a patient if it was for continuity of care. That's treatment information. You can share with a nurse. You can share with med-surg. You can share with other kinds of things. You can share for payment, but we usually have people sign a payment, and you can share for operations, okay? A lot of operational things are things like tracking, infection, control, doing those kinds of things. Operations is a pretty big thing. But one of the other exceptions to HIPAA is this sharing with law enforcement, but it is a limited exception, okay? So if you work in the ED, and the police, because it's usually the ED that gets these requests, and the police come in and they want to know if anybody has been in with a certain profile, you can share information without a warrant, without a separate request, without a subpoena, but in a very limited manner, okay? You can share this stuff: name, address, date of plate of birth, blood type, type of injury. Does anybody got a guess? And I know y'all don't like to participate, but does anybody have a guess on what we used to see a ton of? I know they don't like to participate. A ton of these, what we got? Burns. Right? When we had a lot of meth labs in Iowa, we used to get to the police coming in and asking, right, if somebody had burns consistent with a meth explosion, that kind of thing. And you could tell them that under this exception. The burn question we get now is burns, chemical burns, consistent with being peppered or maced. So we get a lot of inquiries in the ED. Have you seen anyone in with chemical burns on their face consistent with, you know, because some of those ones you can buy like off Amazon and stuff are basically military strength. Okay, they are like, I am going to kill the Predator from Alien versus Predator strength. Okay, they are big time. They are well over the legal limit. Okay, and you can get some pretty severe chemical burns. The other question I get a lot in my emergency rooms is, did anyone come in with a dog bite on their behind? Because they were breaking into the house and the Doberman caught them. Okay, so we get a lot of dog bite questions. Did anyone come in with a dog bite? So right now I get a lot of these chemical burns, and I get a lot of dog bite. A long time ago, what I got was the meth lab burns, okay? So you do get a lot of these kinds of questions, but it is pretty narrow, right? If you do give information out on that basis, you have to log it, right? And you have to tell them what you're doing. But, let's see if I get this. Did not want to advance. Hang on. Okay. Okay, there we go. The rules prohibit, it's touchy today, it's cold. The rules prohibit releasing DNA samples, assessment of blood and bodily tissues, all of the sort of deeper, more complex kinds of things. The rules do not allow us to produce that absent a warrant. And in some instances, if you were a 42 Part 2 program, or if it was mental health, they'd need more than a warrant. They'd need a court order. I mean more than a subpoena. They could get it with a warrant. They'd need a court order, okay? The other thing I see a lot is I see law enforcement departments coming to our ED and telling them they want them to run certain kinds of tests when they have drug overdoses because they're trying to identify the chemicals they're cutting the drugs with so they can track them back to the supplier. You can't do that, okay? Because it would require an assessment of blood and bodily fluids. That's going to require a warrant or a specialized court order. You cannot say to them, oh yeah, this one came in and they had arsenic in their test. Okay, I've got an arsenic request right now. That is not allowable under this. My favorite part about this is the law enforcement wanted to argue with me about what the form said, because they had a form, right? They had this little form they checked off, and they kept telling me that I did not understand the form. So I was eventually forced to tell them I had written the form, and so I pretty much knew how it was supposed to work, right? But that, again, right, I mean, lawyers and law enforcement can be bullies. So it was just two bullies in the same playground. It was fine. It worked out just fine. So you have to be very careful, but this is all the generic, right? This is a lot of times when they come into the ED, they want to know a certain kind of issue, they want to know that kind of stuff, all right? If someone, oh, and don't forget wounds of violence, right? Because anybody who works in the ED, we're going to have wounds of violence issues. That's 147, 111, right? So if you get shot, stabbed, certain kinds of burns, anything that affects multiple bodily functions which can result in death, we have to, if we believe that's as a result of criminal activity or a vehicle accident, we have to report that either immediately or in up to 12 hours, okay? And that's kind of that thing like, so sometimes there's that issue with somebody who comes in with a chemical burn, right? That's not going to be life-threatening. And when you come in with a chemical burn, we don't know if that's in a result of criminal. But in some instances, particularly the shot and the stab, right, it's going to be pretty easy to tell that we're going to need to report that. The issues are going to be different when somebody's in custody, right? And we're going to talk a little more about that when police bring someone in who has not yet been committed, but who is being held because they're a danger to themselves or others. The police can access a little more information than they could access otherwise, right? So when someone is in custody, we're actually going to have some obligations to tell them how they're doing and how things are, because you would prefer that they, not die in jail. So that would be good. Okay, mental health, 228. Iowa Code 228 is really big. And 228 basically says you don't get to give out people's mental health information. Mental health information is protected at a higher level than standard medical information. So in Iowa, it's mental health and HIV/AIDS. Federally, it's genetics, but mostly the genetic issue doesn't apply to you guys. It's more of an insurance issue. Genetics, and then the 42.2 substance abuse. But Iowa has special statutes, 141A on HIV/AIDS, and special statutes for mental health, which include 228 and 229. So generally, disclosures are going to be prohibited. You're going to have to log all disclosures. If you release information, the cover sheet has to say it may not be redisclosed. Okay, there's some really limited things. Emergency disclosure, though, can be allowed, and that's part of that sort of Tarasov standard and some other things. Now, administrative disclosures, right? We typically do that when we do intake. We're going to say how we're going to disclose things administratively, what we're going to do, and we can only disclose if we know that they're going to keep it safe, right? Continuity of care is an exception when you're transferring care, and that happens when we get, right, people who are committed, who are on a hold, and they may be transferred somewhere else. Sometimes that's by order of the magistrate. Sometimes that's because they've petitioned for a transfer somewhere else. Sometimes that's because we don't have any beds, right? And people are going to get transferred. So there's a continuity of care exception to these 228 and 229 rules that allows us to transfer some of this documentation. And if there's an emergency, let's say something else happens, the information can be transferred to another provider in an emergency. So when we have those emergencies, we can do that. One of the things I get from lawyers, and I get from patients a lot, is you can't tell them my mental health status when they've been ordered to us for evaluation, right? If we are ordered to perform an evaluation by a court, the court has the right to access that data. Okay, not the raw test data, but the court has the right to access data because it's going to be court ordered. Families, right? That's our other big place, right? So the patient access, police access, court access, and then families typically tend to be our biggest issues, right? Because when we have continuity of care, caregiver access isn't as hard, right? We have continuity of care, so this is going to be a problem. Under 228, when someone is receiving voluntary treatment, right, there is limited disclosure to a caregiver. Anything that's necessary to assist in care, you can give it to a person who is a spouse, parent, adult, child, adult, sibling. It does not say their next door neighbor who feeds their chihuahua, okay? Or the guy who helped dig them out of the ditch when it snowed. It doesn't say any of that. If you're going to release stuff to the guy who digs them out of the ditch, or the lady who brings them, you know, French toast, or the person who chihuahua sits for them, that's going to have to be by consent. Okay, the statute doesn't talk about that. That's going to need to be by consent. You have to involve, and so you all, the physician or the care provider or the psychiatric nurse, has to certify that these people are involved in care, so that needs to go into the medical record. It needs to say that these people are involved in care. We're not going to meet it, and the request has to be in writing. Patients also have to know who you're giving data to. That goes back to that primary rule of HIPAA, right? You either have to have consent because everything's confidential, or patients have to know. Right? This doesn't require a special consent, but patients have to know. Okay? What we give is limited. It's a summary of the diagnosis and prognosis, listing of medications, and description of the treatment plan. You will also get this inquiry from employers. Right? When people have mental health issues, when they're being treated for anger, when they've been out for substance abuse, when they've been out for a longer-term mental health treatment, like under the FMLA. Right? Some of you probably get asked to fill out FMLA paperwork. I am prepared to believe that each and every one of you is a great doctor or a care provider and that you are brilliant. Let me say to you, you suck at filling out FMLA paperwork, right? Because you hate doing it, right? Don't you hate doing it? You never know quite what to put, and you never know how far to go, and you never know what to do with it, and what the patient wants and what you should do. They're always different things, right? They're all different things. So it puts you in kind of an untenable position, right? It puts you in a very difficult position as a provider to fill that paperwork out. But when employers ask for that kind of stuff, unless it's the FMLA, right? The FMLA, they have to fill out their paperwork or they don't get their leave, so that's an implied consent, okay? But if the employer asks for progress updates and things that are outside of the FMLA, that is only by patient consent, okay? Employers will do that. I get a lot of hospitals who tell me manufacturing employers, that kind of thing, will call and ask for those kinds of updates. They do not have the authority for that unless you have a consent on file from the patient. Right? And I think mental health scares employers, right? Mental health issues scare employers because no one puts on the nightly news the hundreds of people who beat depression or manage depression or whatever. They just put on the news the guy that killed people, right? That if it leads, it's bleeding, right? It bleeds, it leads. And so they don't a lot of people don't understand mental health. They don't understand that people walking around, that half the people that work for them might have a mental health issue. They don't understand it. So be careful about the employment part, okay? Ed Thomas, right? So the Ed Thomas law is another piece of all of this. You guys have dealt with the Ed Thomas law issues several times. I know you've met with local law enforcement, kind of worked through this. But basically what this is that if someone is detained and delivered to the hospital by law enforcement, there is a form law enforcement can fill out when they're going to be released, and then they can request that you notify them that they're going to be released, and they can ask that you detain them for up to basically 6 hours. There's a relatively limited time period for that. It is meant, though, when there is something that is a serious mental impairment. Okay, it is not because somebody broke their arm and the police brought them in to get treated and they fill out this Ed Thomas thing. It is for serious mental impairment. Does everybody remember what happened in Ed Thomas? Anybody remember that? Right? So the guy is in hospital, he gets released, he goes, and he kills a beloved wrestling coach, right? That's Ed Thomas. And that's what that was meant to deal with. So there is a whole process. You can get it on the Iowa, there's a form, you all have it. You can also get it on the Iowa Department of Public Health. There's like 3 or 4 places to get it. But they also have to have an arrest warrant or have issued criminal charges. Okay, so criminal charges have to be pending. So it can't just be, I want to monitor this person. It can't be the one I get in the ED a lot. Let me know when they're gone because I want to see where they're going, right? I get that in the ED a lot, those kinds of things. That is not how that works, okay? Does anybody have any questions? Right, see, I'm used to your staff. They always have a lot of questions. Okay, not enough caffeine? Is that what my issue is? All right. Okay. Other exceptions to collect fees and for research. Carve-out areas are psychotherapy notes, right? And psychotherapy notes, raw test data, Tarasov. Psychotherapy notes, that's the official definition, right? If anybody used to like the Sopranos, Dr. Malfi is the definition of the psychotherapy note. Essentially, it is a note only you see, period. No one else sees it. You don't share it with other providers. It doesn't go other places. It is your note and your note exclusively, okay? And that's a psychotherapy note. And I don't get a lot of those. In all honesty, I don't see a lot of people who keep real, true psychotherapy notes. We get a few of them. But that's prohibited by HIPAA. Raw test data is Iowa. Iowa says that if you do raw testing, psychological testing on a patient, that test data cannot be released to the patient. Okay, you cannot just give them the test data. You don't give it to the court. You don't do any of that. It can be released to another professional. The belief is that the patient won't understand it, will misuse it, misunderstand it, that kind of thing. And so it really does have to be released to another professional. And then this is the Tarasov Standard. Okay, this is the one that we've codified. So if in good faith, right? And when I say good faith, this is not the person who hasn't paid you child support for 6 months. Okay, good faith. Right? So in good faith, you make a determination that you need to hold somebody to prevent or lessen serious and imminent threat of safety. They have the apparent ability and intent to carry it out, right? Then you can call the police and you could report it. This applies only, you don't have to hunt down the potential victim and call them. You don't have to notify the family. You have to notify law enforcement. Okay, so this is about notifying law enforcement. And I get this question an awful lot. Right? I get this question a lot from mental health clinics, from people providing substance abuse care, that kind of thing. We get this question a lot. This is what they said they're going to do. Because remember, this includes suicidal ideation. Okay? I have a plan to kill myself, and I'm taking my kids with me, is the one I got last week. Okay? Those are reportable kinds of things. Those are not going to be HIPAA. Okay? We're going to talk about holds versus commitments. Are we doing okay on time? Are you guys okay? Right. Well, I have strict instructions on time. All right. So we're going to do holds versus commitment. Here's the deal. A hold is when we don't have a court order. There's no court order yet. And there are a couple of times when that can happen. You can initiate it. Law enforcement can initiate a hold. And that means the magistrate hasn't weighed in yet and there's been no other thing. A commitment is when the magistrate has issued an order. Okay, there's some more complexity to it, but that's really basically what it is. A hold is initiated by someone who's not a judge. And a commitment is issued by someone who is a judge. So we're going to have prior court orders. Nobody likes to be held against their will, right? Doesn't make anybody happy. Nobody likes it. There is a process, though, by which people can be committed when you have never seen them. Right? So this is basically an involuntary hospitalization. We see these a lot for people who have really chronic drug abuse, right? And their family becomes convinced they're going to die, right? And they have chronic drug abuse, so a family member with another person by affidavit can file a request that the court have that person committed to a hospitalization or a treatment program, okay? They can then be committed based on that evidence, but they have to schedule another hearing where the person is represented, that kind of thing. So this first one is you could have someone come into your emergency room or come in to be admitted where there's a court hearing, but you all have not seen them yet, right? So that is certainly a possibility, and I think that's always a little difficult and a little discomforting for the physician or the provider when we do that, but that is that one. For the purpose of an involuntary commitment, right, we're going to have serious mental impairment. That can include lack of compliance that results in multiple emergency room visits. Okay? So they amended the law last year that when a family member, let's say family, because it's usually family members or girlfriends or boyfriends, it's usually family members, when they file for an involuntary commitment, if someone has had multiple ER visits, let's say because they've overdosed, or multiple ER visits because they've got a gangrenous tumor, they've got, we've got a lot of stuff that can result that, and they're not taking care of themselves. Sometimes we're starting to see those. And attempts at serious physical injury. So those can all result in that. The second thing that can happen is what's called immediate custody. Okay, so in the first one, they have to schedule a hearing, they do that kind of stuff. In the second one, a family member could make an application and say this person there's going to be imminent harm to themselves or others. They're going to kill themselves, they're going to kill other people, there's imminent harm. So the sheriff can pick them up on the magistrate's order and typically only get ordered to you guys, okay? The sheriff can detain them. Those orders and I talked to a bunch of magistrates right? To make sure, to understand really what they were doing. Those orders can be they're released to a family member, to the care of a family member. Those orders can be that they're released to a suitable hospital. If they are placed with you, okay, so they come in here, you can do whatever medical care is necessary to preserve their life, okay? You can do whatever medical care is necessary to prevent injury, right? So to control behavior. And unless you get consent, you can't do anything else. That is it. Basically, you can keep them alive and make sure they don't kill a nurse or a CNA or a med aid, right? You can keep them alive. But until they go farther through the process on one of these immediate custodies, you got to have consent, right? You got to keep them alive. You're going to have consent. So some of the things that we might choose to do or that would be helpful, right, you will not have the ability to do unless you get consent from the patient. And a lot of times we see people resolve, at least begin to resolve in 12, 14, 24 hours, who will then provide consent, who will then stay voluntarily, do those kinds of things, right? And sometimes we get people who just had a single bad episode, they can resolve within 24, and even though they may be committed for 48, right, or up to 5 days, if they resolve, we would then, in conjunction with law enforcement, contact the magistrate to see if they want to release them early, right? So we have the ability to do that. There's a post-hearing requirement. So when you do these things, when you have the hearing first, there's a post-hearing requirement. Our biggest issue is that the chief medical officer is going to have to create a report to the court, okay? And you only have 15 days to do that. You can get a 7-day extension, but if we failed, if they are committed to us and we fail to meet our reporting requirements, it's contempt of court. They can also be ordered to outpatient, but here's the thing about outpatient, a lot of them fail at outpatient. And so that then necessitates another hearing, and then there's a request for committal. That can be a 2-day or an immediate detention. Okay. Placement order post-committal, they could request to be moved someplace else. That's really what that means. Okay, let's talk about the psychiatric hold. So a couple of times that a psychiatric hold can occur. One is if the police pick someone up and they bring them in for you to evaluate, okay? And you are evaluating that person and you agree with the police officer that they pose an immediate threat, right? They could be psychotic, they could be threatening to kill someone, they could have tried to commit suicide, they could be saying they tried to commit suicide, they were unsuccessful, they're going back for another attempt. There's lots of ways to do that, and that means you're going to hold them, okay? So you're going to hold them at that point, but it is incumbent upon the provider, preferably in conjunction with whoever brought them in, whatever law enforcement brought them in, to contact the magistrate. Okay, because the magistrate then has to issue a verbal order, because you're going to call them. You're not going to all show up in court in suits. You're going to call them, okay? And the magistrate's going to issue a verbal order, and then they have a day, basically, to issue a written order. But if you have someone where there's no court order, okay, there's no court order for committal, there's no court order for a hold, nothing, but you assess that they are an immediate risk and danger, you could keep them with the help of the police, but you got to call the magistrate, okay? Because the magistrate will then enter a verbal order. So this is only meant to be for a few hours, right? And the magistrate could issue a 48 and up to a 5-day hold depending on the circumstances, but the magistrate does that. We can't hold somebody for 48 hours without calling the magistrate, right? Sometimes I have people think that, but we can't hold someone. We have to call the magistrate and get an order, right? Any questions? Okay. So you get that by magistrate order. You get those issues that crop up. There's a bunch of post-hearing things that happen, right? Commitments. Okay, commitment with no prior detention. They have to hold a hearing within 48 hours. That's the first one we talked about. Emergency detention. Typically, you got to hold the hearing within 5 days. Outpatient failure, we start the process over. Post-committal charge, that's when I've been committed, but I want to go to a different facility because you guys are all evil. Okay, that's going to be within 7 days. And then the psychiatric hold is provider initiated. Okay, so that's when that is provider initiated. I'm just trying to see if anybody has any questions or if everybody just fell asleep. Okay, should we talk about elopement? Right? Or as some of my clients say when they just run, elopement. Okay, so we got a couple of different, so I do work not only for hospitals and clinics, but also for long-term care. And elopement is an entirely different process in long-term care. It is governed by a different set of rules. It is governed by different language. It is governed by really massive federal fines. Elopement is really a different issue in long-term care. So when we're talking about mental health issues, the first time is if you have somebody who is court-ordered to you, okay? So if someone is court-ordered for your care and they leave, right? They just walk out the door, or as one I had not too long ago, their girlfriend comes in the door, they take all the medication bags, and then they walk out the door, okay? You are required by law to call law enforcement. There's actually a statute that says that. It's 229-14B, and if they are, because they've just breached court order, right? There is a court order for their committal, okay? What happens, though, if they just show up in your ED, and we haven't assessed them yet, but we're just a little worried about them? They're in the ED, and then they leave, okay? That's going to depend a little bit on whether or not you have engaged in any form of assessment. Okay, because if you have assessed them and you've made an assessment, we're going to talk about that in a minute, but you can have some liability if it is a frequent flyer, right? If it is somebody you see all the time, if every time they come in they have suicidal ideation, if every single time they've self-harmed, that kind of thing, if we notice them in the ED, we need to figure out what's going on, right? Because we can end up with EMTALA claims, weirdly enough. We can end up with malpractice claims. We have another thing. So if we know that already, it's a little bit like having a known drug seeker. Right? When we know we have a drug seeker, when they've been there before, when they've washed out on their pain management contract, and we know that, we have a little heightened obligation. The same is true when someone comes in that we know has attempted to self-harm or harm someone else. The third instance would be when we have assessed someone, but we don't have any kind of order in place, and we assess them. They came individually. They want to leave AMA, and we've assessed them, but then they leave. Okay? There are at least 2 hospitals in Iowa who had EMTALA charges filed against them for patients who were assessed to be at risk and then left. Okay? I don't think EMTALA is the right choice for that, right? I see 1 or 2 of you going, what? I do not think EMTALA is the right choice for that, but I don't know if you've ever dealt with an EMTALA investigation, but they pretty much just come in as if they are the Jolly Green Giant, right? And just stomp on everything. That is how EMTALA works. Okay, so there's some EMTALA issues there, but there are also potential malpractice issues, right? If you let a patient who is at risk and you have assessed them to be at risk, leave, right? So we have some malpractice issues, that kind of thing, which means we have to watch those patients, right? If we're in that weird time where we've assessed them, we believe they need to be held, and we've contacted the police and we've maybe tried to call the magistrate, we've got to make sure they don't walk out the door, because otherwise we're going to create lots of other issues and risks. Okay, and so we have to keep a hold of them to make sure that that's how that's going to work. Questions? Okay, you want my last page? Practical issues. These are the ones I get a lot of questions on. Police conduct in the ER. Okay, I get a lot of police officers who want to be right there with somebody they've brought in, and maybe it's not appropriate, right? Most police officers probably should not be standing while they're getting their CT. They should, those kinds of things. So we get some police conduct in the ER where it can interfere with care. Okay, where the presence of the police officer can interfere with care. Rule number 1, it's all about best interest of the patient, right? Because our job is to keep people alive and healthy. The second piece is elopement, which we've talked about. What about not wanting to test, right? We get a lot of people who, okay, it doesn't even have to be the police, right? A lot of my hospitals get parents who bring their kids in and demand that they be drug tested. I want them drug tested right now. Well, I cannot force a 17-year-old football player who outweighs me by 150 pounds to pee in a cup, right? And neither can any of my lab techs. Nor am I going to hold somebody down and draw blood out of their arm. First of all, because it's not good conduct. Second of all, because I could hurt them. And third of all, because they could hurt me, right? So a lot of times if somebody doesn't want to be tested, if somebody doesn't want to be involved in treatment, we're not going to be able to do it, right? Because we don't get to handcuff them to anything. We're not going to do that. Now, if we have a warrant, one of the things you get police officers coming in with a warrant for a vial of blood. There is some debate on whether or not we draw that blood or don't draw the blood if the patient is violent or unwilling to have the blood drawn. There is a question in how the law works with that, which leaves it kind of open to hospital policy. And I don't know what hospital policy is, but it leaves it open to hospital policy, okay? So the not wanting to test, we have to be very careful. I don't think you force testing on people unless they've proven themselves to be incompetent or a danger, okay? I get a lot of these, the girlfriend who stole the prescription. right? I had a guy come into the not the emergency room, but his girlfriend was admitted. She had lots of painkillers, and he came in and he pulled the IV out of her arm and he took her drugs. Okay, and then he walked down the hallway and he took some more, right? He can get booted, right? You don't have to let him come back in. You don't have to do that kind of thing. And we also get that same issue when people come in to visit a mental health patient or substance abuse patient and they bring drugs with them. Drugs or alcohol to hand off to the patient, right? When we continually find contraband, those people can be asked not to return. Those people can be kept out. And in some instances, when we're bringing a new patient into certain areas and they may have contraband, it may justify a search, right? Searches are possible and appropriate. So we have all of those. And then when we find contraband, you don't get to take it home, okay? Every once in a while. We have found contraband, everything from snakes wrapped around people's waists or down their trousers. I literally got the call, the guy is unconscious, I can't get the snake off him, can I kill it? Yes, we cut the snake's head off, by the way. Those of you who love snakes, sorry, but that's what we did. We also find guns, we find illegal drugs. If you find an improvised explosive device, you need to call the police. Okay, we found those. There's a lot of stuff that you can find when people come in. Contraband we don't keep. Yes, was that a question or a stretch? Oh, good.
About the previous slide. Oh, can you flip back to the previous
I could
slide?
try. This one? That one?
It's about when patients elope. And you said,
Okay, I didn't actually have a slide for that. I just talked about it.
okay, but you were saying that when patients are in crisis, or I'm not sure what your words were,
Okay.
that we really shouldn't let them go, that we need to hold them. Our issue is we can't physically hold them
Right.
while we're waiting. So I'd like to get a little bit more information from you on that as to what our rights are and what the patient's rights are in that interim.
Okay.
Because really, I've given the staff and administration here have given the staff the direction to let them go. We call the police, they find
Yes,
them, and they bring them back.
And that's good direction. Okay, so
I just wanted to clarify
right.
that.
Okay, and I apologize if that was not entirely clear. So we're assuming that a patient has come in and you have assessed them to be at immediate risk for either injury to themselves or others. You want to hold them because you're going to want to get a magistrate order potentially for commitment. Nobody ties them up, nobody sits on them, nobody holds them down, but you do want to move promptly to contact the police and then to contact the magistrate. The thing I want to avoid is that we set them in a corner and we walk away. Someone needs to at least be watching them, so if they are leaving, we can notify the police again. Okay? One of the things that's happened in some other hospitals is the emergency room is really busy. Okay? I had to take my son to the emergency room this week. Okay, I didn't get home till 2 in the morning. I got there at 6 in the evening, right? And there's a reason for that. I get that. I understand triage. I understand all of that. I am a health law lawyer. I get it. But if it had been my pain, I'd have probably walked out 2 hours in because it was just a really, really long time. So and they were so busy. They were very nice, but people could have come and gone, right? And if you've been assessed and we're not able to get you in because you've had a large multi-vehicle accident, you had that kind of stuff, somebody's got to still watch them. That's all I'm saying. So you know that they're there. Okay? I love questions. Anything else? Oh. It's hard. It's a big room.
It is a big room. Kind of the converse of the someone resisting testing. Occasionally we have someone who will come in a blue car with a nicely dressed gentleman in a blue suit and who has arrested that person for OWI.
Uh-huh.
And that person comes at 3 o'clock in the morning and to our ED and says, I would like blood alcohol testing, please. What is, as a community hospital, do we have to give that person that privilege? Can we say, no, we don't do that, come back tomorrow? What do we do there? It seems to put a lot of bees in bonnets when we have that happen.
Okay. Right. So is the person who they've brought in, are they consenting to the test or not consenting to the test?
The person is actually asking for the test because they don't believe the field sobriety that was performed by the law enforcement official. They say, well, I want you to take me to a medical center and I'm going to demand my own blood testing. Thank you very much.
So then that's just a lab issue.
It's a lab issue, but our lab isn't open to walk-ins at 3 a.m. So
Right.
they come to the ED, and then it becomes an issue. Do we have to evaluate this person? What if we do the testing and their BAC is 0.5?
Right.
There's a lot of issues around that,
Okay.
and where I'm not sure
Right.
exactly how to handle that.
Right. So I assume that if we're talking about lab testing and we don't have a warrant and it's not a 321J test, that you'd have to have an order. I assume we'd have to have an order at some point. We don't get a lot of people. I don't normally get a lot of people who want to be hauled in to be tested.
No, it doesn't happen very often. We did have it happens occasionally, and we had kind of a higher profile one that was difficult to adjudicate on the
Well,
fly.
you guys
at
are Ames.
3
All yours are
o'clock
going to
in
be
the
higher
morning.
profile and interesting.
Yeah.
It's going to involve some basketball player or something.
And we do offer wellness testing,
Iowa
so
City's the same way.
someone can walk in off the street and say, I would like my cholesterol and my lipid testing done, and we say yes, you pay $25 or whatever, and we'll draw your blood and do it. So I looked at it as someone just coming off the street asking for wellness testing, but it does bring up a host of issues. If
Sure.
is that person impaired? Do they come to the ED asking for testing? Do we
Right.
have to do an assessment? It's a difficult position, and
Right.
it'll probably happen again.
Right. Well, there is no rule that because you serve a community or and nothing as far as I know in your bylaws or any of those kinds of things that require you to staff the lab 24/7 or require you to have lab testing available 24 hours a day, right? So for that particular issue, I mean, is the question going to then become that you would have to call someone in from on call to come in and do it?
No, the question is, it's not someone's not coming to the hospital out of medical necessity.
Right.
They're coming because they have a medical legal issue that they want us to help them with.
Right.
And
So-
do we honor that request even though we don't do chain of custody collection for forensic specimens?
Right.
It's their right to do that. So then, how is it our right to say,
Right.
"Oh, you can't have it here. You have to go"?
Right. So, right. So what I would assume is they would come into the emergency, they would have to register as a patient, and then they would request a lab test, and then you would perform the lab test. But they would have to because somebody's got to pay for it, right? I mean, someone's got to pay for it, and their insurance isn't paying for that. So they're going to have to personally pay for it. So I would assume that they would come into ED, they'd register as a patient.
I think that's where the issue is coming from, where Jamie says, I mean, our ED staff does not want to have to perform an assessment at that point to register.
Mm-hmm.
So that's where we get in trouble. They have, like you said, they have a blood alcohol of 0.5,
Right.
and they want this done. And then are they responsible for following up, even though the patient doesn't want that? They just want to come in.
So when you say follow up, what do you mean?
These are the two medical directors of the lab.
Okay.
I think the problem is that this is getting into a little bit more we have to discuss here, but the problem is who's taking responsibility, because the medical director of the lab is actually probably should be taking responsibility, even though we haven't seen them. But then the ER physicians don't want to. What's that? So now that is the medical director's responsibility at 2 in the morning. We are both pathologists, haven't seen a patient, a live patient in like 20 years. So we have to make a decision, if they have a blood alcohol level of 0.5, what do we do with them?
Okay, so it's not, so that particular issue really is policy driven, right? Does someone become a patient? Do we assess them? If they do come in through the ED, you have to assess them, right? Because that's going to be an EMTALA issue. You have to create a medical record when you draw the blood. right? There has to be some, I'm not entirely certain what your process is, but there's got to be some record that we drew the blood. I mean, what happens if they get an embolism? You know, I mean, we have to have some form of record for that. The one we get more frequently is when police officers bring someone in who will not consent, right? And then we're into 321J. But again, when someone doesn't consent and they are capable of consent, that creates an entirely different issue. And then the third one is when they come in with a warrant, right? And then that's a different issue as well, because that changes the chain of custody issues. So, but the first question strikes me as a policy issue as opposed to a technical legal issue.
That makes me feel better, actually.
Okay, good. Well, I hardly ever make anyone feel better, so good. Yes.
Yeah, frequently we'd see patients that were elderly that came in driving, and we probably shouldn't be driving anymore. We'd sit down and talk with them, and they would say, no, I'm still fine. I'm still going to keep driving.
So my grandma's been in to see you? Is that what you're telling me?
Yeah, right. And,
Okay.
and we talk to the family, and family says, well, I don't really want to get involved in this. Is there a HIPAA violation if we notify the
DOT?
I'm sorry?
The Department of Transportation, the
Yeah,
DOT?
right, yeah.
So
And
there are
that came up all
sometimes
the time, yeah.
Right. There are some times when you're required to report to the DOT, right, where they've had lots of seizures, massive seizures, that kind of thing. You're required. So I think you would have to you would have to be very clear in your assessment that allowing them to drive forms a positive danger, right? Because that's the good faith assessment for positive danger, and then it becomes a public health exception. Okay, that's to protect public health. So I would think it would be rare, but it could occur. Right? You just have to be very careful, right? It has to be in good faith, and you have to feel comfortable in your assessment.
Okay.
That's a good question, though.
When a law enforcement officer makes a request, when a law enforcement officer makes a request about or has an inquiry, and you have to make a note in your records, where are we recording that? You know, if it's specifically about a patient we have, do we make the note in that patient's chart, or are we making it somewhere else?
Okay, so that is in, and I apologize for saying this like 3 times now. That is a little bit of that is a policy issue. Okay, the legal piece that requires you to make a note is that it has to be recorded on the log, what's called the HIPAA log, the log that allows you to track who has accessed the record. Okay, your EMR may have a way for you to note that, and I don't know who does the EMR, but your EMR may have a way to note that, or it might have to be through a tab or something else. So it depends on the configuration of your EMR. I know that was not helpful at all, and I apologize, but it really does depend on the EMR configuration.
Okay.
So HIPAA, okay, requires that we log access to patient records, which are not for treatment, payment, and operations. Now, it technically requires that we log TP&O as well, but they have never issued the rules. It's hilarious. We're like 16 years out, and they've never issued the rules. But for these third-party access, right, so when third parties get it, you have to have this log that says who got it, why, under what authority, when, and basically what was released.
So it sounds like you're saying basically if you're releasing information on someone's chart, then you have to make that
Sure.
notation
Or if a police officer
wherever.
comes in and says, you know, I saw that guy you just treated, what's it, you know, and you're not necessarily, I mean, even when you just know it in your head, right, you don't have to go back to the chart, you still have to log that the police were told. So, like, if he grabbed you at the Casey's to ask you about someone he thought you just, that's still medical stuff and it's going to have to get logged. And you can also say, you know what, you're going to need to call me at the office, at the hospital, whatever. I mean, I'm not a big fan of being ambushed at the Casey's. It happens a lot, but I'm not a big fan of it. You are not looking at me like that helped at all.
Danielle says there's a tab.
Is there a tab? Okay.
They have the answer?
Yeah.
She always has the answer.
But she doesn't want to talk. She just sank. That was weird. Okay. All right.
Thank you.
So there's got to be a process, and every hospital differs. I don't know what your process is. Other questions? Yes, sir.
I just had an interesting patient that this reminded me about 25 years ago that came in with been poisoned with rat poisoning.
Ooh.
And with bleeding disorder. And he had not taken it himself. I believe he hadn't tried to commit suicide or anything. And he did not want to notify the police or have the police notified. And yet obviously I think somebody had tried to kill him.
Uh-huh.
Is that if he tells me, well, I don't want you to notify the police, what should, in today's laws, what would be the correct course of action there? If
My girlfriend is poisoning me, but don't tell anyone?
Right. Well, basically somebody was poisoning him.
Okay.
And he was a real sketchy guy. I mean, he'd had problems with the police before. I ended up actually calling the police and telling them.
And I think you would.
Yeah.
So I think now, potentially something like that can even fit under the wounds of violence statute. Because the wounds of violence statute has been broadened over the years. Originally, when it was enacted, it was really just getting shot or getting stabbed.
Okay.
But it's been broadened to include injuries or things that affect multiple body systems.
Okay.
And so I think the wounds of violence. And the other thing, in terms of being a provider, if you are reporting to the Department of Public Health or the police in good faith, right, in good faith because you genuinely believe there is a crime, there is an issue, there is that kind of thing, there's a fair bit of protection for you within the statute for good faith reporting, okay? It's just when they're like your ex-husband that we start to get into trouble, right? Or, that girl you really wish would leave your boy alone or that kind of stuff. I mean, we do, or that person, or, the person who, bought the house you were trying to buy. You'd be surprised what people get upset about. Or maybe you wouldn't. I'm a lawyer. I see it all every day. You guys see it up close and personal. So, all right, what else you got? Anything? This is like a going, gone moment. Anything? All right, I'm going to call it good then. Oh, whoa, wait. There he is. You're that guy that comes in 2 minutes after the movie started, too, aren't you?
You didn't mention anything about sexual assaults. If the woman doesn't want to report it to the police, is there still a requirement to report an obvious injury and sexual assault, or is the woman who has been injured, if she was fearful that the perpetrator would get back to her, what are the responsibilities of the ED in a case like that?
So sexual assault occupies a very complicated space, okay, in terms of law. I mean, it's not complicated in the terms of no one should be assaulted, but it occupies this very complex space. If you have a shot or a stab wound, right, those are clearly delineated under the wounds of violence statute, and you would need to report the shot or the stab wound. There's also like a percentage level of how much you're burned, that kind of thing. If you have someone who has, let's say, significant contusions, they've been raped, they have, black eye, that kind of stuff, but not injuries to cause death, right, or likely to cause death, not a shot or a stab wound, it becomes a lot more complicated. Because what every law enforcement officer in the world, including the FBI, will tell you is the most dangerous time for a woman who's involved in an abusive relationship is after she reports her abuser, right? And so you're right, you could lead, and a lot of people who are abused, and we always talk about women, but it's also men, right? A lot of people who are abused go back to their abuser multiple times or live in the same community with their abuser, those kinds of things. So I think that is a conversation with the person, and if you choose not to report it, you need to have a why, right? She's been very clear. She feels that she's in danger, that, that her children are still, whatever it is, you need to have a why. There were a couple of cases early on where attorneys, particularly Roxanne Conlon, alleged that not reporting was a violation of the wounds of violence, but they didn't really go very far, right? Because you don't fit cleanly within that statute, and you kind of have to, that's one of those ones you have to manage, right? You kind of have to manage. I have a lot of people that go to the same nurse or that kind of stuff, and then they don't want it to go any farther. They choose not to go forward. They choose not to prosecute. They choose, that's one of the big frustrations for county attorneys, is that even if you do report and it goes forward, they might not cooperate, right? So I think it's a balance because, again, we go back to the best interest of the patient, and we have to talk to them about their living situation and what is in their best interest, short-term and long-term. So it's very complicated, but I lean on the side of unless there's something clearly that you have to report, okay? So like an abused woman comes in and the kid also has contusions, mandatory reporting, right? Anytime we're talking about children, we're going to have mandatory reporting. But she gets some control over whether she reports or not, okay? Other questions? Okay, you can ask me another question I can't answer, because that makes me feel bad. Yeah, you live in Ames. What about impairment?
Well, so
are we talking about like after a basketball game or?
A little bit.
Yeah.
So they come into the ER. They're slurred speech, appear to be intoxicated, or maybe we even know that they're intoxicated. We've driven, and they leave in their car.
Driving.
We're okay to report that, but we can't say, "Hey,
Yes,
they're legally
please, answer that one.
intoxicated." We could say, "We observe them."
Yeah. Yeah, she says you can report them, and I say you can report them. So that's
and the
two.
same thing if it was like, "Hey, we're giving you an opioid. You can't drive. You need to have a ride
Oh, so they came in for like a
for a treatment, or
colonoscopy,
pain
and
or
you don't want them to drive, and they're
What about
driving
that?
anyway?
In that situation,
I don't know. What do you want them to do if they've given them a painkiller and they're not supposed to drive? I think it's hard to monitor that sometimes. Yeah, she was really happy because she could just answer that one. I always like it when I can answer them too. I don't know. How's that? I don't know the answer to that question, right? Because you tell people they should drive, and if you have surgery, you also tell them they shouldn't sign any contracts or do anything like that, and they still do. So people do that kind of stuff. I think it's going to here's what I would say to you. You are the expert in that instance. And if you have given them an injection, if you have given them oral meds, if you have done something and you believe they pose a positive risk, then I'm okay with you calling the cops. Okay? But I'm probably, it's going to depend a little bit, right? You have people who have enormous tolerances for opioids, right? Who can basically down the whole bottle and it doesn't even affect them. So it's going to depend a little bit on what the circumstance is. This really does come down to, balancing what the circumstances are. And the thing I care about is that you can articulate a reason, right? They were slurring their speech. I had already given them the opioid, blah, 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 blah. They told me they were driving. That was not safe. Because at the end of the day, I'd rather somebody yell at me because I told on them than that they crash into a busload of kids, right? That's always, because it is never a busload of criminals they crash into. It is not. It is not a busload of bad people. It is a busload of children and nuns. I am just telling you. That is what happens.
thank you.
Yeah, you really could just send me a list of questions and I could try to figure them out, but it's going to take me a while. Okay, what else we got? Anything? All right, thanks.